Good afternoon.
Good afternoon, Mr. Chair, members. I would like to begin by thanking the Chair and the committee staff for working with my office and with me so really efficiently to be able to accept the amendments that have been proposed, and I appreciate the flexibility that you have shown me in this process. Thank you.
Thank you. And the latest set of amendments are being handed around, I believe,
Okay.
that we came to agreement on. So the ones we worked on last night.
Yes, sir. And I accept the amendments and the language, and thank you very much for working with me.
Thank you.
So AB 1342 supports the California Commission on the Disability Access by increasing its funding and establishing certain requirements upon the CCDA, the Division of the State Architect, and commercial property owners which relate to disability access. AB 1342 achieves a strong coalition of support from the disabled, the business, and the legal communities. The balance that we were speaking about, we're achieving here. This broad support is a recognition of the valuable role that the CCDA can play in aligning the needs of the disabled and the business communities. The Commission acts as a liaison to create a balance between access for the disabled while working with the businesses to make compliance feasible and realistic. The CCDA currently provides several resources to business, such as user-friendly lists of some of the most common ADA violations. However, their capacity to be proactive in advocating for disability access is severely limited by their low level of funding and lack of staff support. There is broad agreement that all Californians will benefit from empowering the CCDA to realize several of its educational and outreach goals, which will ultimately enhance disability access and awareness throughout the state. This bill's requirements upon the CCDA and the state architect improve the way that businesses can proactively make their properties compliant. For example, the CCDA will help businesses identify certain certified access inspectors in their area if they are interested in having an inspection done to ensure that their properties are compliant. Again, this bill is supported by the board of stakeholders, and I thank the chair for his interest in this issue. To elaborate further on the CCDA and its funding needs, I am joined by Angela Germont, the Executive Director of the CCDA.
Good afternoon.
Good afternoon. It is truly a pleasure to be here this morning or afternoon at this point.
We are in the afternoon now.
Indeed, we were quite pleased, the CCDA, to hear the author's written bill to provide the long-needed support of the efforts of CCDA. Today, I was actually, sadly to say, thrilled to hear the number of people quoting the reports and the findings from our commission. But I say mixed feelings because, sadly to say, because of our limitation, we have not been able to deeply research as fully as we like the truly continuous opportunities to provide more than just anecdotal thoughts, because that's what has been happening for all this time. We hear the terms and the fragrance usage of lawsuits and what's going on, but without the actual detail that CCDA has begun in our research, you will be hindered until we provide that type of information. And so, for sure, this is one of the aspects that we gladly long for the resources to provide the legislation. In October, we had the great opportunity to have stakeholders to combine from all aspects of our community, our business community, our disabled community, government, local, statewide organizations to come together, and everyone continually said this was a rare opportunity that has not happened within the state of California. And CCDA is the true vehicle to be able to provide a place where everyone can neutrally come and feel safe to be able and believe that there's some place that can provide this type of support and knowledge to be able to go forward. We've created a strategic plan with that group of stakeholders, and we know that with this information, with the resources, we'll be able to further provide opportunities, the legislation, and all folks, people from California and visitors of California can be better served by our work and support of all that's going on within our community. So we thank you so much with this opportunity to provide us more resources to further the support of this needed idea of bringing access for all Californians. Thank you.
Thank you. Any other witnesses in support?
Thank you. Once again, Ruthie Goldkorn, Californians for Disability Rights Legislative and Executive Committee, Chair of the Disabilities Caucus of the Democratic Party. And this is a very necessary entity. It was created years ago. They have been operating with a shoestring and doing an immense service to the disability community and to the state of California. That is their job, is to serve the state of California representing persons with disabilities and making sure that everybody understands our civil rights are everyone else's civil rights, and there are mechanisms of enforcing those civil rights, whether you like them or not, whether the building codes are good or bad. That is not CCDA's job. CCDA's job is to represent the state of California and its millions of residents who have disabilities, the future residents with disabilities, and those of us who were the surprise party from 1946 to 1964 acquiring disabilities. The funding for this is incredibly important. It is long overdue, and we thank the Assemblyman tremendously for the opportunity to support you and to finally fund with a minuscule amount. We think it's tiny, but hey, you know, you got to start somewhere. So thank you very much, and thank you, members of the Judiciary Committee.
Thank you. Next witness, please.
Hello again. My name is Gwen Butler from Fremont, California. I strongly support this bill. It is needed. So go for it.
Thank you. If you could just give name, affiliation, and your support, please.
Jennifer Barrera on behalf of the California Chamber of Commerce, and we are also supporting funding the commission. Please just support it.
Thank you.
Jacqueline Zanowski from Disability Rights California, and we support the bill.
Sabina Tucker with the Consumer Attorneys of California in support.
Anthony Goldsmith, CDR, strongly support the bill. Much needed. Thank you very much. Great work.
Ken DeVore, National Federation of Independent Business, and we support the bill.
Thank you. Any other witnesses in support? Seeing none, any witnesses in opposition? And just for clarification, you've all been handed out the details that we worked on last night between the committee and the author. So if anybody has questions with that, make sure you raise them before we take a vote on the bill. So the recommended action is do pass as amended to appropriations. Any comments, questions from committee members? All right, seeing none, Mr. Steinnorth, you may close.
Again, thank you, Mr. Chair, and thank you to the committee and the members. I do appreciate the fact that we've been able to achieve what I see as a very unique balance between the interests of the disabled, the business, and the legal communities. I urge your aye vote.
Thank you. Call the roll, please.
Stone?
Aye.
Stone, aye. Wagner?
Aye.
Wagner, aye. Alejo? Alejo, aye. Chow?
Aye.
Chow, aye. Chu? Gallagher? Garcia?
Aye.
Garcia, aye. Holden?
Aye.
Holden, aye. Mainshine?
Aye.
Mainshine, aye. O'Donnell?
Aye.
O'Donnell, aye.
Your bill is out.
Thank you very much.
Thank you. And our final item is item number 11, AB 1141. Mr. Chow.
Thank you very much, Mr. Chairman and members. AB 1141 has two components. First of all, it would reenact and make permanent summary adjudication statutes that that inadvertently sunsetted. And number two, it also removes a disparity in current law by allowing a plaintiff to seek both pre- and post-offer expertise fees. In 2011, SB 384 established the ability of parties to move for summary adjudication of issues even if the motion would not completely dispose of a cause of action or affirmative defense, if the court determines that the motion will further the interest of judicial economy. SB 384 also require the consent and stipulation of all parties and the court as a precondition for the motion being filed. The summary adjudication provisions inadvertently sunsetted on January 1st, 2015, eliminating a legal tool that promotes judicial economy. This bill reenacts and makes permanent the summary adjudication provisions that previously existed in a CCP. Secondly, in 2005, an amendment to AB 1742 inserted the word post-offer into subdivision D of CCP 998. AB 1742 was a Judiciary Committee omnibus bill that was non-controversial. There is no record in the legislative history of the bill explaining the intent of this particular amendment. As the statute currently reads, when a plaintiff rejects a 998 settlement offer and fails to receive the better judgment at trial, he or she can be subject to an award of both the pre- and the post-offer expert fees paid by the defendant. However, if the defendant rejects a plaintiff's 998 offer and fails to do better at trial, the plaintiff can only seek post-offer costs of the services of the expert witnesses. This inequity in the application of CCP 998 applies more pressure on plaintiffs to settle rather than the defendants. This bill will eliminate this disparity in treatment. Specifically, the bill reenacts, as I stated, and makes permanent the provisions in statute relating to summary adjudication that inadvertently sunsetted. And second, the bill removes the word post-offer from subdivision D of CCP 998 so that a plaintiff can recover the cost of the services of expert witnesses only in the same manner as defendants who currently may be awarded both the pre- and the post-expert costs. I have a couple of witnesses here to testify in support of the bill. Let me turn to Mr. Mike Below.
Thank you. Witnesses in support.
Thank you, Mr. Chair. Very briefly, Mike Below on behalf of the California Defense Council. The summary adjudication provision of the bill was non-controversial. It deals with summary adjudication of issues with stipulation of plaintiff defense and the judiciary. I should not have allowed it to sunset, and for that I apologize that you need to deal with it now. As to the second part of the bill, we support the notion that plaintiffs and defense be treated the same with respect to 998 offers, so we support the bill.
Thank you. Next witness, please.
Good afternoon, Mr. Chair and members. Savina Takar with the Consumer Attorneys of California, and we're pleased to co-sponsor this bill. I'm going to speak to the amendments to CCP 998. This bill was enacted, or this statute was enacted 44 years ago in order to encourage parties to make and accept reasonable settlement offers. So prior to 2005, this standard was doing its purpose, and for 34 years, it was fine. This bill will return us back to the original intent and create an equal incentive for both parties to settle. For these reasons, we respectfully ask for your aye vote.
Thank you. Any other witnesses in support?
Chair Member Dan Pone from the Judicial Council. We support Section 1 of the bill to reinstate the partial summary adjudication provisions. Section 2, dealing with the 998 issue, the attorney's fees and cost issues are typically outside our purview, so we have no position on Section 2 of the bill.
Thank you. Any other witnesses in support? Seeing none, witnesses in opposition.
Chair, Catherine Pettibone, Civil Justice Association of California. This one we had sent out to our folks and had varying responses depending on their industries, and so we apologize for getting feedback back late and doing an oppose unless amend. We've had good conversations with the sponsors, so we're hoping we can work something out. According to some of our folks, this structure in 998 exists for a reason. And what they've told me is that when you have a plaintiff who brings a case, they're going to have more information about the reasonable costs of what is appropriate settlement. They're going to have expert fees. They're going to have a lot more knowledge. A defense isn't going to have that until they actually get into a case closer to trial, and therefore there's a timing imbalance. They're not going to know what the reasonable value of a case is until they've had an evaluation, and then they can make an offer or accept an offer. So what they're concerned about is that the plaintiffs would front load it and drop an offer late, and they wouldn't have a chance to really have evaluated it. I do think there's something that we can work on in regards to that. In regards to the timing of it, I don't know what happened in 2005 in appropriations. Many things go on in appropriations we don't always have clarity on. But in the case that was referenced in regards to this, the court noted that as early as 1971, when it was enacted, that defense was able to get their pre- and post-offer expert fees, and that was in reason because of the fact that it takes longer to evaluate it, and that it was part of the reasonable and necessary in defense. This award of pre- and post-expert fees isn't automatic. It is a may, and the defense does have to show those two things. So I have seen cases where defense do not get it. I don't think it's an automatic, where they're getting all these fees in these cases. So I'm not sure the imbalance is as strong as we think when we first saw this. Again, these are our concerns. Happy to continue to work on this issue. But for these reasons, we have to do an oppose unless amend.
Thank you. Any other witnesses in opposition? All right. Seeing none, I'll bring it back to the committee, and we'll note for the record that we are happy to take an action here to clear up Mr. Belot's error previously. And so thank you. Any questions, comments from the committee? Ms. Wagner?
I do. The first part of the bill is easy. The second one, though, actually, those are not, to my mind, unreasonable concerns, and they do explain why there might have been a what appears at first to be a disparity, but in practice it doesn't work out that way. And so I guess I would ask Mr. Belot, if you could, for the committee, explain to us why we should not be concerned about the Chambers and CJAC's position on this.
Well, thank you, Mr. Wagner. I was here in 2005. I was not aware of the change. It was inadvertent as far as I can tell. It certainly wasn't a thoughtful decision by the legislature that I know of. As far as we could tell, the law had existed in the way that we are restoring now for decades, and I had never heard of the imbalance. There is a question of what you know about, what the defense knows about a case and when versus the plaintiff, and I understand that, and our people debated that. But they took the position that all we are doing is returning to the law as it existed for I believe 34 years was the number that I was told, and that was fine.
Okay, but we might be returning, but again, are we finding a solution to a problem that doesn't really exist? If nobody noticed it for the last 10 years, is it really something that would prompt this legislature to now get in the way of an issue that has been identified as potentially a reason for an imbalance, and that in practice it actually is balanced, and we are now fixing something that really isn't broken?
Like I say, I'm afraid I can't add much to what I've already said. We have had concerns about 998s for years, and we've discussed those with the plaintiff's bar, and we've had various proposals back and forth. I had never heard about this being a problem.
Other comments, questions from committee? All right, Mr. Chow, you may close.
I would be happy to continue the dialogue with the Chamber folks and respectfully ask for your aye vote.
Okay. I am looking for a motion, which is due pass. There's a motion and a second. Thank you. Would you call roll, please?
Stone?
Aye.
Stone, aye. Wagner? Wagner, no. Alejo? Aye. Alejo, aye. Chow?
Aye.
Chow, aye. Chu? Gallagher? Garcia? Aye. Garcia, aye. Holden? Holden, aye. Mainshine? Mainshine, aye. O'Donnell? O'Donnell, aye.
That bill is out. Thank you.
Thank you
We
much.
do have two items on call. The consent calendar for one. And then item 12, AB 1154. So on the consent calendar, call the absent members.
Alejo? Alejo, aye. Chow? Chow, aye. Chu? Holden? Holden, aye. O'Donnell? O'Donnell, aye.
And that's item 13, AB 553, 14, which is AB 583, 15, AB 885, and 16, AB 1123. Those are all out. And the last item that is on call is item number 12, AB 1154. Mr. Gray's bill. Call the absent members.
Holden? Holden, aye. O'Donnell? O'Donnell, aye.
That bill is out. All right, we'll be open for a little bit if members want to add on to votes that they had missed earlier. Whatever is easy.